And the complaints filed by Mr. McFerrin bring us here today, where originally he alleged that he was denied parenting time going back to the weeks beginning June 30th through July 7th, including 4th of July holiday, essentially all summer of 2023, additional dates July 28th through August 4th. And then most recently, September 8th through 10th. The last parenting time, which I believe is agreed by both parties, took place back on June 11th of this year. 21-day notice was sent to parties as well as subsequent notices to the complaints filed, and Ms. Jacobs did file responses to those. And the parties also just recently resolved a motion filed by Ms. Jacobs to modify parenting time. But under the order from 2021, there was parenting time ordered for Mr. McFerrin, and that stemmed to during the summertime, which is the basis of most of this complaint, that he would have week on, week off parenting time from Friday at 4 p.m. until the following Friday at 4 p.m., beginning the first Friday following the end of the school year. During the summer, until the recent modification, that Mr. McFerrin would have parenting time 3 weekends on, 1 weekend off, from Friday after school or 4 p.m. if there is no school until 6:30 p.m.
And that was during the school year?
Pardon?
That was during the school year?
Yes, Your Honor. Yes. And then till 6:30 p.m. on Sunday. And that was school year parenting time was to begin the last Friday before the beginning of the school year. And that it leads to the most recent complaint that Mr. McFerrin had filed for the dates of September 8th through 10th. Holidays are outlined as well. It was his 4th of July holiday. He would have had the minor child from the 4th of July from 9 a.m. July 4th until 9 a.m. July 5th. And there was both obviously an interim order and then the most recent referee recommendation order, which did make some modifications to the parenting time.
All right. And Ms. Mullen, do you know if the parenting time that was ordered occurred this past Sunday?
I am not certain if the parties, I saw that was to begin September 24th, I believe.
That's correct. So did that parenting time occur this past Sunday, Mr. McFerrin?
Yes, sir.
Okay. All right then. So Ms. Jacobs, the court takes notice of the testimony that you presented at the trial that was conducted last week. And the court's already made findings in order after that trial. And the court's also read your responses to the show cause, the complaints for show cause. Was there anything else that you wanted to say today?
No, that's about it.
Okay. And just so this court's clear, in my notes, it looks like you school started on September 5th. On Friday, September 8th, you withdrew Jedediah early. And then on Friday, September 15th, Jedediah just stayed that whole day. Is that right?
Excuse me, Your Honor. Sorry. Yes, I did. The only reason why I did it that way is because I just wanted to wait until we went to court. That way Jedediah felt more safe.
Okay. All right. Mr. McFerrin, was there anything that you wanted to say regarding the issue of denials of parenting time?
Nope. I just wanted to let it be known.
Absolutely. Okay. So, this is a contempt hearing, and the standard of proof for civil contempt is more stringent than in other civil actions. The proof of contempt must be clear and unequivocal. There must be clear and unequivocal evidence that the offending party made no meaningful effort to comply with the parenting time order. MCL 552.644 states that if a court finds that either parent has violated a parenting time order without good cause, the court shall find that parent in contempt. The statute continues that for the purpose of that section, quote unquote, good cause includes, but is not limited to, consideration of the safety of a child or party who is governed by the parenting time order. So I guess, first of all, as to the safety issue, this is a case where this court has already issued a referee recommendation and order finding that Ms. Jacobs failed to prove by clear and convincing evidence that parenting time with Mr. McFerrin would cause mental, physical, or emotional harm to the child. So this court has essentially already concluded that they're, to the extent there are concerns about safety, that those concerns don't rise to a level that would avoid a finding of contempt, or that would constitute good cause to not follow the parenting time order. I mean, certainly, and this court did find in the most recent order that the child, it certainly is apprehensive and anxious about reestablishing contact with Mr. McFerrin, given the circumstances, and the court has described those circumstances in that order. But again, this court did not find, and does not find today, that parenting time for the child with Mr. McFerrin is a safety risk. The evidence is simply not there for that.
Your Honor.
And Ms. Jacobs, I mean, again, you've all been given the opportunity to provide testimony. Ms. Jacobs, the court has heard your testimony regarding things that you've observed from Jedediah. This court finds it curious that you haven't even gotten that child in counseling yet, given your purported concerns. So, I mean, again, the court has heard your testimony and has weighed that testimony, and does not find that visitation or parenting time for the child with Mr. McFerrin creates a risk to the child's safety by clear and convincing evidence, or would otherwise constitute good cause not to follow the order. I'll say this, though. The evidence also showed at the most recent trial that Mr. McFerrin did not attempt to get Jedediah for parenting time all summer. A parent has to at least attempt to pick the child up in order for the other parent to be held accountable for denying parenting time. If you don't try to get the child, it places this court in the position of having to read people's minds. Certainly, Ms. Jacobs's text messages and her other statements indicate that she was unwilling to facilitate parenting time. But because Mr. McFerrin never actually went over there this summer to try and get the child, it's impossible to say one way or the other under the more stringent evidentiary standard that we have to apply at a show cause hearing. It's impossible for this court to find that visitation would not have happened. It's unknowable. So, and that's one of the reasons why this court ordered that all exchanges moving forward take place at Culver's. That's why this court recommended that, you go, you get a receipt just to prove that you were there, that you tried to do the exchange. Because if you don't try to do the exchange, this court is not going to, hold the other parent in contempt when the challenging parent didn't actually try to get the child. But on Friday, September 8th, Mr. McFerrin was to pick the child up from school, and the same thing on Friday, September 15th. It was impossible for him to do that because Ms. Jacobs did not ensure that Jedediah was physically present throughout the entire school day. It wasn't a medical issue. Ms. Jacobs intentionally pulled Jedediah early on September 8th and then didn't take him to school at all on the 15th. I understand that she believes she has her reasons based on her observations of Jedediah, but based on the evidence that this court has heard, this court firmly believes that if Ms. Jacobs had demanded it, that Jedediah would have stayed in school and would have gone to school for the full day on both of those days. And that would have made it possible for Mr. McFerrin then to pick the child up to begin his parenting time. So for all of those reasons, this court does not find that Ms. Jacobs is in contempt for any of the missed parenting time this summer. for the reasons stated. This court does find that Ms. Jacobs is in contempt for failure to facilitate parenting time on Friday, September 8th and Friday, September 15th, due to her failure to have the child present in school until the end of the school day. And so accordingly, the court is going to award Mr. McFerrin 2 weekends of makeup parenting time from Friday until Sunday. Those weekends will be made up as follows. Mr. McFerrin will receive Ms. Jacobs' first full weekend in January of 2024. And he will receive Ms. Jacobs' first full weekend in February of 2024. All exchanges are to occur at the Culvers midway between the parties. I know it's not exactly midway, but it's the Culvers relatively midway between the parties. Strike that, Miss Mullen. No, okay, let's do it that way, just to be sure, because I don't know if there's necessarily going to be school on these days. So for this makeup parenting time, the exchanges will occur at Culvers, 6 o'clock on Friday. Until 5 o'clock on Sunday. Additionally, Mr. McFerrin, did you have to miss work to appear at today's show cause hearing?
Yes, just about 2 hours.
All right, and what do you get paid per hour?
22.
Okay, so Mr. McFerrin is awarded sanctions in the amount of $44, which is essentially the amount that he had to forego from earning to appear at today's show cause hearing based on the court's finding of contempt. Who's the child support payer in this case, Ms. Mullen?
Mr. McFerrin is.
All right, so that will be basically credited towards his child support obligation. That's the court's order for the reasons stated. Ms. Jacobs?
I did have a question. The receipts from Culvers, are we supposed to get them, or was that just a suggestion?
That was just a suggestion. If there's a future show cause hearing, that's one way you could prove that you were there and that you were willing to do the exchange.
Okay, because I just wanted to make sure, because I got mine, but Hassan never went in and got his, so I just wanted to make sure.
Well, that's going to make it impossible for him to prove that he was there, which creates kind of the same problems that we had today. So,
So
all right.
I just want to make sure.
Yep.
Thank you so much.
All right. Thank you.
Thank you.
Bye-bye.